Good afternoon, everyone. I'm Indranil Chaudhary, CEO of Lexplosion Solutions, and it is my pleasure to welcome you to our webinar, Assessing Organizational Readiness for the New DPDP Regime, Strategies for Compliance and Data Privacy. This session is particularly timely as the draft Digital Personal Data Protection Rules 2025 were released just a few days ago, providing some clarity on the Digital Personal Data Protection Act of 2023. At Lexplosion, we work closely with several hundred clients across industries, helping them navigate compliance challenges. Over the past few weeks, many of you have sought guidance on preparing for the new data privacy regime, and today's discussion is aimed at addressing some of these concerns. This 90-minute webinar will be broken into three parts: a quick introduction to the rules, a panel discussion involving four leading industry experts who will give us their perspective on the draft rules, and finally, a live question and answer session where we'll try and answer some of the questions from the participants. We already have over 50 questions which have been sent to us in advance. We might not be able to address all of them in the allotted time, in which case we will mail you our responses wherever possible in the next few days. One quick note, barring the live Q&A at the end, the rest of the session has been recorded slightly in advance to avoid any last-minute technical glitches and also to accommodate the availability of some of our speakers. In the first part, I am joined by my colleague Kanishka Bose, a fellow lawyer at Lexplosion, who will help us unpack these rules and their implications for businesses. Welcome, Kanishka.
Thank you, Indranil. It is definitely great to be here. It's a very timely webinar. The release of the draft rules have indeed sparked widespread discussions, and I look forward to delving into how businesses can prepare for this new data privacy regime.
Right. To set the stage, let me briefly outline the context of these rules. Released on the 3rd of January 2025, the draft rules provide operational clarity to the DPDP Act 2023, addressing aspects such as consent, data breach reporting, and cross-border data transfers. Stakeholders have until the 18th of February 2025 to submit feedback via the MyGov portal. This is a critical opportunity for businesses to contribute to shaping the regulatory framework.
That's right, Indranil. The rules aim to operationalize the Act and includes provisions for a phased implementation. We know that some aspects like setting up of the data protection board has effects, it's taking effects immediately, while others will follow as notified.
Right. So essentially, from the date of the rules coming into force, the Data Protection Board and its various constitutional aspects will come into effect, while the rest of the substantive provisions of the rules will become relevant or will become applicable only from the date which is prescribed by the central government, which is likely to be at least a few months, if not maybe a year from the date of the release of the rules. Let us now examine the key provisions of these rules and their implications. Kanishka, could you start with the consent-based processing and notices?
Of course. So the rules mandate that the privacy notices must be standalone, must be easily understandable, and without relying on any supplementary documents or hyperlink. Each notice must provide a detailed account of the purpose of the data processing and also an itemized description of goods and services enabled by such processing. This, in my mind, is a significant shift that will require businesses to completely redesign their privacy policies and consent mechanisms.
Absolutely. Privacy by design, for example, becomes very, very crucial in this context. And to add to that, the emphasis on standalone notices reflects the Act's intent to ensure that data principals are not overwhelmed or misled by complex privacy policies. Now, this aligns with global trends in data privacy where transparency and simplicity are becoming key principles. Consent managers, whose roles and responsibilities have been fleshed out in these rules, will play a pivotal role here, providing platforms that enable data principals to give, manage, and withdraw consent seamlessly. For businesses, especially those with large scale operations, this means rethinking how they communicate with their customers while ensuring compliance.
Absolutely. In fact, consent managers play a pivotal role also because they're enabling the data principals to manage their consent seamlessly. This brings us to another critical area, which is part of Rule 6, the reasonable security safeguards. Security is central to the rules. Data fiduciaries are required to implement safeguards such as encryption, access control, regular data backups. Additionally, they must retain logs for at least 1 year to facilitate breach detection and investigation. This retention requirement, though, while it is necessary for accountability, will definitely increase compliance cost for businesses.
Absolutely. And, as a small business operator ourselves, there are a few additional points that I wanted to discuss, Kanishka. First of all, the obligation to have reasonable security standards is there even in the current Information Technology Act's SPDI rules. Just that in the rules there, they specify that if a company has a ISO or IEC 27001 certification, and if they get it annually validated, then that in itself will be sufficient to establish that they're maintaining reasonable security standards. Now, while that sounds prescriptive, maybe for smaller businesses it would be far much easier if there was a similar indication in these rules, in the draft rules as well. Additionally, data fiduciaries are required to ensure that data processors with whom they're sharing personal data are also maintaining reasonable security standards, which seems fair again in concept, but might be difficult for smaller data fiduciaries to execute against some of the bigger data processors, cloud infrastructure providers, for example.
Indeed, the discussion on the reasonable security standards actually nicely segues into the next topic that we'd like to discuss, which is on the intimation of data breaches. So, on intimation of data breaches, we know that the rules have introduced stringent reporting obligations. Data fiduciaries now must notify the Data Protection Board immediately upon discovering a breach, but also provide a detailed report within 72 hours outlining the breach's nature, impact, and even the mitigation measures.
Right. And it is important to clarify that apart from notifying the board, which it has to do twice, once immediately upon knowing about the breach and the other within 72 hours with greater details, there is also a requirement to notify each affected data principal, and that must also happen without undue delay, though exactly the time is not mentioned, and probably the amount of specificity that is required is lesser than what will be required to be provided to the data protection board within 72 hours. Now, businesses need to ensure that their incident response frameworks are robust enough to meet these timelines, which brings us to the next interesting aspect covered by the rules, Kanishka, requirement relating to data retention and erasures. As I understand, Kanishka, these rules address only certain classes of data fiduciaries, and when it comes to this, right?
Yes, absolutely, Indril. So the rules specify a 3-year retention period for certain types of data fiduciaries only, including e-commerce entities, which has more than 2 crore registered users, or online gaming intermediaries with more than 50 lakh registered users, even social media intermediaries with more than 2 crores registered users.
Correct. I think for other data fiduciaries, they must determine retention periods based on the purpose and processing, which again, while it provides them with flexibility, also adds to a certain amount of ambiguity. As far as these identified data fiduciaries, these three classes are concerned, they must also notify data principals 48 hours before erasing their data, which will allow the data principals the opportunity to preserve the data if they want to.
Absolutely. Now, turning to the provisions for children and persons with disabilities, the rule emphasizes verifiable consent. This is extremely important and interesting as well. So, for children, the parental consent must be verified using reliable details, which is either available with the fiduciary or relying on voluntarily provided identity and age details or virtual tokens issued by authorized entities. For persons with disabilities, however, the data fiduciaries must ensure that the consent is by legally recognized guardians under relevant laws.
Right. And this, Kanishka, is an area where I believe businesses must tread very carefully. While the rules provide some flexibility, the lack of specificity around verifying guardianship for persons with disabilities will pose a challenge to them. Also, just a thought, in a country like ours, I'm not so clear how one can confirm the parent-child relationship in all cases using technology. Would it eventually require data fiduciaries to verify the age of every person wanting to benefit from their goods and services and not just children? And how will that play out with that whole concept of purpose, limitation, and consent requirements? Establishing robust internal processes as well as the role of the consent manager, for example, in handling such cases will be crucial. I know our panelists will be able to throw more light on this, but before we go over to speak to them, Kanishka, maybe we can quickly touch upon the entire aspect of cross-border transfers and obligations of significant data fiduciaries.
Sure. Dhruv. So the rules, in general permit cross-border transfers in general. So, there's not a lot that is, different, but for certain types of data, the transfer will be permitted if the SDF meets conditions specified by a committee, which is required to be, set up by the central government. It is not clear what type of data, these are, or which countries they cannot be transferred to, adding to some ambiguity, in this entire concept of cross-border data transfer piece. Additionally, for all data fiduciaries, not just the SDFs, the central government may provide additional restrictions in transferring data to foreign states or any of their agencies.
Right. And these obligations, while we understand will be necessary for accountability, will definitely introduce some operational complexities, especially for businesses with global operations. It underscores the need for agility and preparedness. With this, we'll move to the panel discussion. But before we do so, I encourage our audience to reflect on how these rules impact their compliance strategies. Do reach out to Lexplosion, do reach out to any of us if you have any questions, if you want us to provide you any assistance. And of course, I'm confident our panelists will provide extremely valuable insights from their experiences as well. So without any further ado, let me introduce the panelists for today. We are privileged to be joined by Mr. Rakesh Maheshwari, a former government officer having worked for more than 35 years in the Ministry of Electronics and Information Technology and retired as Senior Director and Group Coordinator, Cyber Law and Data Governance, an engineer in electronics and commerce and communication by qualification from Delhi College of Engineering. During his tenure in the ministry, Mr. Maheshwari handled activities relating to the Information Technology Act, Personal Data Protection Bill, social media regulations, cybersecurity policies, Aadhaar Act in various capacities, including Group Coordinator Cyber Law, GC Cybersecurity, GC for Certain, and GC for UIDAI. We are also very privileged to be joined by Ms. Hena Datta, Global Head, Legal and Compliance at MV Solar System Private Limited. Hena is a seasoned legal professional who has leadership roles in organizations such as Lead Squared, MediBuddy, Pearson, and MediAssist. Her core proficiencies encompass mergers and acquisitions and data privacy, among many others. Hena is also recognized for her strategic legal advisory, policy formulation, and in-depth research capabilities, making her a trusted leader in corporate legal and compliance frameworks globally. We are also extremely privileged to be joined by Dr. Bharat Saraf, Group Head, Global Data Privacy, Data Governance and Data Ethics. Dr. Saraf is currently spearheading the formidable task of establishing and developing a fully autonomous privacy function for the PhonePe Group, having enabled the rapid launch of privacy-compliant regulated businesses, including payments, insurance, mutual funds, accounts aggregators, and ONDC. Dr. Saraf has always championed a privacy-first culture for organizations, supported by a doctorate in law, extensive global privacy experience, publications in international journals, and contribution to the public discourse on privacy compliance. He has served on the International Association of Privacy Professional Asia Advisory Board, being recognized as Fellow of Information Privacy, having achieved CIPM and CIPPE certification from the privacy body. And of course, last but not the least, a long-standing friend of Lexplosion, Bibhav Pradhan, legal lead, digital data, media and marketing services, and the data privacy advisor for South Asia for Unilever. Bibhav graduated from the National Law School, Bangalore in 2011 and has been with Unilever ever since. Bibhav currently leads the legal team partnering with the 1,800 million euro beauty and well-being business and also leads data privacy for Unilever in South Asia. Over the years, Vibhav has been involved with a variety of roles within Unilever, supporting multiple businesses, verticals with IP and brand protection, advertising, product claims, substantiation, mediation, product development, and commercial contracts. Thank you to all of you for taking your valuable time out for this session. We really, really appreciate it. As we have already mentioned, the rules have just come in, so this is probably the most opportune time to have all of your views on this. So without going any further on on this, I'd like to quickly ask all four of you for your preliminary views, your general views on the DPDP rules. So maybe we can start with you, Mr. Maheshwari, and then move around the room. So if we can have your views, you've been involved with the entire process of the formulation of these of the new privacy regime for India. What are your views on the rules?
Yeah, so first of all, thank you. Thanks a lot for having given me this opportunity of maybe presenting my views here today. So rules, of course, the law had already conveyed most of the intentions of how it is going to be there in respect of personal data protection implementation in India. The rules are more or less in line with those expectations. In fact, a draft version somehow leaked in December 2023 was already in place. So people had a good view. Maybe what I like to say is there are certain aspects, particularly with respect to data localization, with respect to reasonable security practices, and the contentious issue of dealing with while dealing with children's data, taking the verifiable consent of parents and the consent in the context of disabled persons with disability. So these are some of the aspects which have been very I'll say well brought out. Now, to what an extent do they create the obligations, additional obligations on the data fiduciaries and maybe other stakeholders is yet to be seen. I also believe, maybe just one more minute, is with respect to the notifications of the significant data fiduciaries and the startups, or maybe the exempt government organizations, which probably will happen independent of the rules. So that is what has not been brought, but probably was expected by the industry.
Right. Dr. Saraf, I know that you've been, one of the people who the government has from time to time sought views of on the rules, including more recently in the last few days. So, what are your thoughts on the rules? What have you been expressing to the government? What kind of changes can we expect after the first round of consultation?
Good evening, everyone, and thank you, Lexplosion, for this very opportune time that we are having this webinar. I think this is going to help a lot of people across the ecosystem. Just calling out that the views expressed by me today will be my personal views and do not reflect either the position, policies, or procedures of PhonePe or my previous organizations that I have been a part of. Coming to the rules, I think the timing of the rules was very important. I think across the ecosystem, nobody, although everybody was waiting with bated breath for the rules, it had been 16 months, but January 3rd was a very big surprise for all of us. I think everybody was just waking up from the New Year slumber, and suddenly the rules pop out and people were trying to verify whether they are the right ones or not. But having gone through the rules and done a first-hand review, plus the recent government consultation, which I was a part of in Delhi, the rules clearly, as Mr. Maheshwari rightly pointed out, do follow the SARL mechanism, which is simple, accessible, rational, and actionable. They are more principle based, giving the data fiduciaries a lot of leeway on how they want to go about their implementation. Examples being, it talks about in Rule 3, what should be the contents of the notice, what all should be informed to a data principle. However, the mode of issuing those notices on apps, on websites, is left to the data fiduciary. So from that standpoint, I think it does give data fiduciaries a lot of opportunity to go about their implementation basis, the industry basis, the data principles that they cater to. But having said that, I think there were a few expectations, especially after a lot of consultations that the government undertook, and we waiting for the rules for 16 months. Examples being, I think there should have been a categorization and a clear qualification of a significant data fiduciary. Because the comments on the rules will also depend on who actually is a significant data fiduciary. So currently, the government has left it to a later date to define who would fall under that categorization. There is also expectation that had arose among the community to classify different data fiduciaries. Because currently we only have two data fiduciaries under the Act and the rules. One data fiduciary, which is a common data fiduciary across who process any sort of personal data, and the other category is the significant data fiduciary. So there is no differentiation or different classes of data fiduciaries, and hence what this will entail is a lot of compliance burden on small and medium enterprises who do not have the tech capability or the wherewithal to comply with all the particular requirements. The third important thing was, I think, the unique concept of consent manager. What I believe is METI should have looked around in the ecosystem and found a friend in the account aggregator ecosystem, which is very closely doing what the consent manager is expected to do. And maybe they should have included a provision where they could have allowed a consent manager to quickly be onboarded, an account aggregator to be quickly onboarded as consent manager so that the ecosystem and the machine starts rolling. Having not done that, I think consent managers will take a long time to develop and for them to start addressing and providing all the solutions that are required under the rules to the data fiduciaries. So largely, I think this is my overall observation of the rules. But of course, as the discourse progresses, there will be a lot of opinions and views that will come about.
Right. Hena, over to you for your preliminary views on the rules that have been published on the 3rd of January.
Thank you, Indranil, and thank you, Lexplosion. Thank you to all the panelists. My 2 cents on the DPDP, which I want to touch upon quickly, is one is data breach. The data breach, actually, we anticipated that data breach will have a segregated breach, considering the impact of the breach. However, the rule that has come, it is actually treating all the data breaches uniformly and with the same level of reporting to the board, reporting to the data principals, without grading the data breach categories as in how serious it is or how mild it is. So we were expecting or anticipating some data breach gradation of reporting and treating it by the law. The other point is though we have mentioned that the security protocols that organization has to take. However, the detailed guidelines, we have certain points that tells that these are security measures, but technically the detailed guidelines is not seen in the current rules. That is on breach, and the other part is there is also a brighter side. Now we have the rules where we have a detailed list of obligations of a data fiduciary and the consent manager. So now, the area where who will manage the consent and what are the nitty-gritties of a company to have kind of the organization and technical parameters and the budget of 2 CR of their net worth, right? So today we have visibility on the consent managers, on the data fiduciary, on the board, and we have reached somewhere that we can start today. So I think this draft is a good to go, and we can start with it. I'm sure the amendments will come over the time as we learn from step to step. Secondly, the Section 3 to 15 and 21 and 22, these are the areas which will come later. It is not yet, it will come at a later stage. So I think
Right.
I have a thumbs up for the rules. Yes.
Okay, that's Vibhav, do you have a thumbs up for the rules or
Um,
is it somewhere like this?
So, just thank you so much. Hi, everyone. Great to be back again. Just two things before I start off. One, I do not partner the beauty and well-being business anymore. It was in my previous role. But the second thing, I just want to reiterate what Dr. Saraf said is the views are personal, not attributable to Unilever in any way. I have mixed feelings about the rules, similar to Dr. Saraf. A lot of positives in terms of flexibility through the vagueness that they've tried to achieve. The intent is right. However, one of the things I just wanted to, we will be talking about the rules specifically when we move ahead. Just one thing that I think the government as well as we need to be conscious of is that ambiguities are maybe great for larger organizations with access to experts like us, law firms, etc. When it comes to MSMEs, etc. One of the difficult problems that the rules have is that unlike the GDPR, which has recital, which does give some insights to the intent objective, how the rule came about, it becomes very difficult to interpret what it really entails or was thought about by the lawmakers. And that makes it very difficult for smaller MSMEs, SMEs to interpret this. And this may turn out to be more onerous or would lead to cost of compliance, a high cost of compliance, where they'll need advisory around this. That's the limited I would want to say because we've taken a lot of time on the thing. We'll move on and delve deeper into the specificities when the further questions are asked.
Sure. In fact, the next question is also for everybody in the room, but I'll start with you, Bivab. So a lot of our, attendees today are organizations, and representatives from organizations. So with the draft rules in place, what are the, changes that, people would think that they should start implementing in their organization right away?
So if you see the rules vis-a-vis the act that was notified, I do not think there are any significant changes except some of the provisions that have come about, like the cross-border restriction on STFs, etc. But from a compliance perspective, I completely agree with what Dr. Saraf said. It's a principle-based approach. That's what Meeti has been talking about. I've heard Mr. Maheshwari speaking about the same, and the minister also, the honorable minister, talking about driving compliance in organizations proactively rather than waiting for the law. I think that's what we should do. What I would encourage people to do is maybe rely on foreign jurisdictional guidances to delve a little deeper into these principles, because when I read the rules, and that's why I have a mixed feeling, is because the rules don't bring a lot of clarity in a lot of aspects which the act already delved into. A bit of clarity, but it still leaves a lot of vagueness, which is a double-edged sword. So I do not see much changes from what it was prior to the rules being notified. It's the same approach that the organization will have to take as they had when the DPDPA 2023 was notified.
So Dr. Saraf, you want to add anything to that? Any changes that you...
Yeah, apart from Rule 3, which is basically calling out notice, from a compliance standpoint, I think that is where especially data principals and consumers in a B2C setup are going to see a lot of change, because it calls out the notice has to be transparent. It has to be on a website, on a mobile application, with contact details of the privacy officer that has to be contacted. So apart from Rule 3, I think most largely the rules focus on two aspects. One is the entire setup of the consent manager, including its registration and its independence, responsibilities, and obligations. And the second larger part of it is mostly heavily focused on the operationalization of the administrative side of the law, which is the Data Protection Board, etc. So from an organizational standpoint, I believe if you have started the journey of complying with the privacy, there is not much that has changed. In fact, you need to pick up pace now because you have something in sight. You will quickly have a timeline to adhere to. So you either start picking up pace, and if you have not started your journey yet, then I think it is time that you start talking to your leadership, setting the tone from the top, assessing your budgets, finding the right talent, and getting the compliance ball rolling on the privacy side. So that is what I believe would be the two different aspects basis how and where the companies are in their journey of compliance on the privacy law.
Sure. And
Kanishka, before
what
we
about,
move to the others, I just wanted to also check with Dr. Saraf specifically, because from the preparation perspective, especially because both you and Viv have mentioned about the small and medium industries and how it will impact them differently, there's this entire reference to reasonable security standards. And historically, there was a prescription that if you're ISO, ISC 27001 certified company, then you are maintaining the reasonable security standards. Now that's gone away. What kind of suggestions would you have? And this is a question that I would gladly pass on to Mr. Maheshwari and Hina as well. What kind of reasonable security standards would you suggest people should start considering taking to be in line with what is required under the DPDP Act and rules?
So I think the rules calling the reasonable security and standards specifically shows the intent of the government that every data fiduciary not only adheres to the larger standards like the ISO ones you mentioned, but they undertake certain specific requirements as simple as anonymization, masking of the data, ensuring you have a good third-party risk management system in place so that whenever you are engaging a processor, you ensure the processor has the wherewithal and capability to handle the personal data of your data principles. So from a small and medium enterprises perspective, I think they need to start small. Don't look at the bigger picture right away because apart from the reasonable security standards and safeguards mentioned, there is a whole lot of compliance activity that you need to carry on before you get to that step. So at this stage, I would say take one step at a time, and this is especially for the SMEs in mind and not for the larger organizations. And then basis your journey, and of course, what we are hearing is we will be getting about 18 to 24 months to get in line with the compliance requirements. So basis where you land in your journey, I think that is where you start to take these baby steps and slowly move towards the maturity of what is expected under the rules and under the act, especially from a security and a safeguard standpoint.
Mr. Maheshwari, I would appreciate your thoughts on this whole, especially because of the technology aspects involved in this.
Yeah. So I completely agree with Mr. Bharat when he said that maybe instead of focusing on the larger models of information security management systems, whether it is ISO 27000 to 27701 or maybe other models, maybe some prescriptive text has already been given. And to that extent, it does help, particularly the small and medium companies, to be able to have their security system in place around these, I'll say, broader guidelines. So, but the bottom line will always be that the breaches are prevented. So,
Right.
as long as that is being fulfilled, maybe the job is done. Rest, in any case, whether you, mention what has been mentioned, or maybe you follow whatever standards you want to follow. If there is a breach, the organization is supposed to be reporting it to the stakeholders, to the board, and consequences may follow. So maybe these specific mention of what is required will probably help the small companies to prove their due diligence. That's it.
Right. Hina, sorry, I kind of jumped in, but going back to Kanishka's original question on how does the rules change the way an organization like yours, which is in the manufacturing sector, view the preparation journey for the DPDP Act and rules?
Coming from manufacturing, we are like it is B2B, and we don't have much of or a big data company like my previous organization where it was all healthcare data or the edu or the child's data because I was with health with edutech also previous to this. Here the scope of getting larger data PII is less. However, the employee part of it, we have so many employees across India and across globe also. And firstly, we have to ensure that the employee data, the starting point or the point where we actually capturing the data, how we are processing, retaining, and purging from employee perspective. Another point where we get the individuals or the personal data of our business salesperson, of our customer or a vendor or a partner. Even they are individuals and those are processed. So there are 2 points for manufacturing sector. One is the employees, other are the individuals whom we connect from other organizations across. So there are areas where, first of all, I can think of revisiting the policy. Now that we have certain data points of ensuring these are the protocols we have to maintain, and if there is a breach, what has to be done. So I think the policy revamping is the first thing which I will want to do, where we have set steps of, if this happens, this will be next step. So accordingly, policy revisit. And I think for me, from legal perspective, the introduction or the amendment of our confidentiality agreement and data privacy agreement, these are the two things which I can think just now before
Sure.
anything starts. Yeah.
Sure. So I know that Dr. Saraf has already suggested that there are indications that this will be 18 to 24-month journey from the time that the rules actually come into play. But Mr. Maheshwari, this is a question that several of our panelists and people who have joined the session have asked. What can we expect? I mean, will we get enough time? What are your thoughts on how much time do companies have from the time that the rules come into force?
In fact, companies were already looking anxiously for all these draft rules, and probably they will like the consultation to be closed dot on 18th February. It's only the Honorable Minister who has conveyed that if there are requests, maybe it can be extended. The fact remains that there are so many of these rules published in one go, which finally needs to be formally published, I mean, as the final rules. Going with the experience that I have, it takes at least 2 months for the rules to get finally published. So April end, in any case, I mean, that's the time when the parliament session, the budget session will actually be over and government will be maybe a bit more relaxed in terms of taking such I'll say bold actions. So April end, and then you add, let's say 18 months, you already are moving into 27. So there is per se enough of time, but it's also equally important that it's not just about making changes. I mean, you need to understand the existing system, the existing practice of data collection, processing. Then it has to be correlated with the purpose limitation and storage limitation. So technically, maybe from today onwards, or when the rules become operational, that time onwards, as to how exactly the policies will look like. But you also need to take care of whatever legacy data that you have, and particularly those of us who are dealing with, I'll say, children data, and they have already been enrolled as children. Maybe after 2 years they become adults. Maybe they continue to be children, and if they continue to be children, maybe even with legacy data, I have a lot to do, because then I have to practically retake their consent, bring in the parents or the guardians, and so per se, while there is a reasonably good time available, the time to act is now, at least doing the full data discovery, understanding where exactly it is being shared, on what terms and conditions it is being shared, and review of all those things. In fact, most of it was already conveyed by Hina when she talked of the changes likely to happen. Thank you.
So taking that cue, Bibhav, I wanted to ask you, about verifiable consent of parents before processing the data of the personal data of children. So what are how do you think organizations will comply to that? As an organization, how would you start obtaining that data or categorizing children data now that it has to be categorized separately, and then parental consent is required? How would you go about it?
And
So I think
before,
this is one.
Bibhav, you can take it up. Something that Kanishka and I briefly touched upon before we moved into the panel discussion was, what does this really mean? Does it mean that you will eventually require the to know the age of everybody who you are catering to? Because without that, how would you know whether somebody is a child or whether somebody is an adult? And to Mr. Maheshwari's point, since the implementation will happen over time, what has somebody converted from being a child to an adult? So that entire piece about verifiable consent, and I think views of all the speakers would be valuable for this. Maybe starting with you, Bibhav. How are you viewing this whole piece about verifiable consent?
So verifiable consent of parent as well as lawful guardian is a tricky one. I think while in our industry we're not heavy with children's data, there may be one-off cases. We have a strict policy against not advertising or marketing to kids. However, it's a global policy defined differently because children in India is under 18 as opposed to what they're defined in Europe, with the possibility of going as low as 13 if the member states agree or pass a legislation, right? And nowadays, if you see, the access to technology is quite widespread. 18 would that would lead to a lot of children accessing social media and a lot of other services that are available on the internet. One of the things, at least I would see, and then as you would have heard all the panelists, that we'll need to start acting on it on a principle basis. So a reasonable approach to interpretation would be required. Now, the first thing that I'm hoping the rules would address in the consultation and the government would do is that they need to expand the purposes for which verifiable parental consent may not be required. I'll give you a very simple example. If for example, it's a private organization, apart from educational organization, delivering services for cognitive development, or hygiene awareness campaign, or a game which just has some elements of collecting first name of a child, no phone number, nothing. It's just on social media. We deploy a game. There's a hygiene related game with germs, etc., being killed. And that's the only thing that you're taking along with the name of the school of the child, or maybe their favorite color to come out with a song, etc. Right? Now, it's deployed for children to raise awareness on hygiene. Now, these are issues that are relevant and in the interest of a child. Now, do you want to start collecting Aadhaar, sensitive personal data of parents to verify that relationship with the child and take consent? I think it need not be. But right now, as the rule reads, when read with the Act, it does feel that you will need consent if you are deploying services or accessing data and processing data of a child. Now, what I'd say when it comes to verifying whether that person is a child or not, I think it's been debated. That's one of the concerns. I would approach it in a simple manner. I think it's very difficult. Otherwise, that you will need to implement services that actually helps verify it being a child, which is also leading to excessive collection of data. I would say that there are certain services which may not be deployed for children, right? Things that like if I'm actually creating games, for example, maybe for children, then there is a need and there is a reasonable possibility of children playing that game. But I'm running a D2C website, the high possibility of it being used by adults. Products are relevant for adults. I'm not selling products and marketing it to kids. Then there, I would assume, and I would at least start with putting certain terms and conditions which restrict access to people below the age of 18. Maybe additionally, if you really need, would be the verification of sort where they'll tick a box stating that they're above 18 years of age. But I think going overboard, unless the service is sensitive or data being collected is sensitive, to verify whether that person is a child may not be required at stage unless the government is really mandating towards this. So it's more of a balance, but I'm hoping the government does also consider there being data processed which are not sensitive or may not be. Like there may be instances where I collect the data and delete it immediately. There may be restrictions created for certain kind of services or parameters that the government can create, where this entire onerous compliance is not required, except certain critical services that are being provided to the children.
Dr. Saraf, your views on this?
Yeah, totally agree with what Bibhav said, because clearly you cannot have a singular applicability of parental verifiable consent for all use cases. Currently, also with the recent government consultation that happened, I think there were a lot of queries and questions related to the same point. So my view is that there should be certain category of exceptions. Now, having said that, I think there are two important points that we need to consider. One, coming from a financial services industry, I know how painful it is to do a KYC of a customer, to keep it updated, and actually ensure that it is verifiable and true, right? So that is a huge cost of compliance, and that exactly is being passed on similarly under the Privacy Act to verify the parents of a child. So that is going to put a lot of cost of compliance and a burden, plus also collecting that data, collecting excessive data, as Bipam mentioned. I think all these are going to be points that will have to be really scrutinized, and actually certain exceptions will have to be provided to ensure children get access to certain services. The second important piece is, I think India is on a digitization story. So if you look at right from the villages to our metro cities, I think children are hooked on to social media, trying to learn not only the social media side, but I think they are getting a lot of insights, and they are developing their entire knowledge base basis interacting online, right? Now, as soon as you put in a verifiable consent mechanism and adding that cost of compliance to certain organizations, I think that is going to deter a lot of children accessing data, accessing online media, which is really helping them come out of their I mean, it is helping them to be more connected to the globalized world. That is how I would put it. And that is going to be taken away from them if there is going to be a hurdle of a KYC from a parental and a guardian standpoint. So these are the two points that come to my mind. Of course, on the operational side of it, there is a lot to be desired. Including how you are going to perform the KYC, what KYC documents are acceptable, is it going to be the birth certificate, how are you going to verify that the child belongs to the same parent? I think there are, because there are a lot of variations on the documents itself, right? Your Aadhaar name, your PAN card name doesn't match. I mean, the government is trying to get a sync on that for adults, leave alone children matching with their parents. So how are you going to operationalize all of that? I think these are some of the questions which the government will have to address eventually, rather than just putting it down in rules and expecting the organizations to go about the KYC process.
And just to pick up from what you said, Dr. Saraf, and maybe this is something that I can ask to Mr. Maheshwari, on this whole thing about, a lot of children do learn a fair amount from social media. And there are many first generation learners in this country, right, whose parents do not necessarily have the levels of literacy that are required for them to go online and provide the kind of consent that we are looking at. How does the government, how is the government likely to deal with that set of people? Because otherwise the digital divide is likely to be even more. I mean, families like us, our children, we will find the easy way to go through a consent manager and provide the required consent. But what happens to, people in, rural areas with probably lesser access to knowledge and information and technology?
Yeah. So maybe I take a completely 180-degree approach as of now, because points Mr. Vibhav and Mr. Saraf have already conveyed, and the complexities involved have already been conveyed. Actually, if you see the way the rules have come up, it is the act as well as the rules which need to be seen together to really understand the expectations from a stakeholder. And therefore, in this particular case, if you look at section 9.5, which does mention that if a platform is verifiably safe, and those mechanisms will have to be developed, and maybe a certification mechanism will have to be developed. But in case that gets developed, the age of consent actually, that child, that age can be brought down by the government. And that takes care of a lot of such issues. I will also like to mention, and this is something which has not been per se covered in the rule, but is there in the law. Then, of course, if you look at the intent of the government, that by putting this word verifiably, they also probably have got stuck as to how to get out of it. And courtesy the schedule, wherein maybe certain kind of entities, so based on maybe the kind of entity that you are, certain exemptions have been given, and the kind of functions that you perform, exemptions have been given. And because they are in the schedule, therefore there is always a possibility of increasing it. Beyond this, I will also like to mention that India is a country of innovations. At one time, maybe there was a program, at least in certain states, of starting with the sort of a registry, a common number being given for each birth that takes place. And if that happens at a central level, something like UIDI we will have in future, so that we have all the complete repository and a unique number being given to every child. Just an idea, I'm throwing. And maybe based on this number, sort of a yes, no kind of thing happens, and the verification happens. Beyond this, probably government is not expecting that you need to prove that you are the parent, because the parents' names and the children name, given the kind of society that we are and we are going to be, will not at all match. So government is not looking at those kind of verifiable things that you have to be the parent. You can be actually any adult, but unfortunately the word reliable has been added. Now that reliable is creating a bit of confusion. So I'm sure on this rule, a lot of consultations still need to happen. It has to become more and more practical. Section 9.5 provisions somehow need to be enabled to make it still growth oriented. Everybody should be able to participate, but this is something which is eagerly awaited, in spite of the rules having been declared.
Before I move to Hena, on a lighter note, the less able students in school often is to look around for parents to sign their report cards towards the end of the year.
That will also happen.
So that might also become a norm in case of verifiable consent, unless blockchain or some other mechanism is found to kind of create that kind of lineage structure that is required. Hena, I know that currently you're in the manufacturing sector, but you've been in the healthcare sector, where there are some exemptions which have already been provided from the point of view of verifiable consent. What are your views on how this will come into play before we? We're already 45 minutes into this discussion. I'm conscious of time, so we will have to restrict it to one or two other principles that we can talk about. But before that, Hena, your thoughts on the verifiable consent piece.
Yes, to continue from where Mr. Maheshwari has left, that there are certain areas where we can see certain parameters already mentioned in the rules of how we have ensured verifiable consent. And on that, to continue from there are two references. One is the virtual token mapping, and another which I can think of is the DigiLocker of service providers. So I can see a ray of hope. What was not there previously, today these two components and mapping of or ensuring that we can verify the existent or the parent is there through these two modes. It is not very clear, a gray area, but yes, we are in a path to actually ensure that child data is not misused or not openly moving. Because I have a first-hand experience, I'll tell you. One of my house help's child has made an account and he has mentioned the age of 18 years plus, though he's just 13 years. So there are ways where people will, people generally they misuse. Then how do we capture it? So challenges are still there, but we have to work together towards ensuring that these parameters, technical, organizational, these are learned and people are, we get proper technicalities from the security measures, and so we can proceed in a flight mode. However, from your point, as there are exemptions given for the consent, the clinical establishment or the healthcare professionals, education, your daycare, your schools. So I think the transportation also is aligned with the school. So the part B or the part A of fourth schedule is I like it a lot because the industry which I've worked on, those are exempted. I have seen, and this is required. But on the broader side, controlled by the retail use of a child, and when that has to be actually controlled by the data fiduciary is something we have to look forward and see how it goes. Yeah.
Right. So moving on to the next concept, and completely aware that we are slightly short of time and we do need to take some of the live questions as well. But there is this whole piece about cross-border data transfer. And I think many of us kind of assumed when we just read the act that it will be a simple case of a small list of maybe 15, 20 countries which will be blacklisted, and then otherwise the transfer of data will be reasonably free. Now, through two different provisions, one with regard to significant data fiduciaries, where we're still waiting for some clarity, and on the other, where there is a certain potential restriction, where in case of significant data fiduciaries, there's a discussion about the central government coming up with a committee and identifying certain types of data which cannot be transferred. And in the case of general data fiduciaries, this overall concept of not being able to transfer information to certain foreign states and their agencies. This entire piece has lent some kind of confusion, especially amongst a lot of our global clients, where the question inevitably coming is that we have to by default share a fair amount of information with our parent company, in some cases with the region, because of pure plain simple things like employee data, some amount of customer data which needs to move from one country to the other. And I'm sure that's an issue that all three of you are facing. So how are you dealing with it, or how are you planning to deal with it, starting with you, Dr. Saraf, because while I wouldn't want to say it for sure, it seems quite likely that your organization will eventually be classified as a significant data fiduciary, I would think. So, so keeping that in mind, how are you viewing this entire piece about cross-border data transfer?
On a lighter note, I'm not sure what are the qualifications of a significant data fiduciary are going to be. But yeah, we are on a journey of compliance, and we would love to be categorized as a significant data fiduciary eventually. Coming to the cross-border rules, the requirements or the rules which are specifically calling that out, I think we need a lot of deliberation and consultation. What I see from the rules, the government is trying to do is they are just trying to hold back the restrictions at this stage. One clear messaging from the government that we are hearing is there are a lot of sectoral restrictions or requirements on data localization, as simple as the payments data being localized by the RBI. So government does not want to jump the gun at this stage, and hence the indication from them is that they are going to constitute this core committee who will maybe sit down with these sectoral regulators and try and understand the restrictions which are currently imposed on certain industries with respect to localization. So clearly, that is one point that we need to wait and have more clarity from the government on. Second, I would say there are no restrictions at this stage, so I think we should not be currently concerned on whether I can transfer data being an MNC, whether that be employee data or customer data, if you do not have sectoral restrictions. I'm sure the government will engage, considering how they have gone about the consultation and seeking feedback from the industry. On cross-border as well, they will engage because there are a lot of international relations that they need to be careful about. One, because if you look at GDPR gives equivalency status to other countries for transfer of data basis their local jurisdictional laws. So for sure, I think the government will look at all these equivalency requirements, not only the GDPR, be that the POPI in South Africa, be that the PIPL in China, or any other global laws. I'm sure the government is cognizant about that particular fact and will take a decision post consultation. And I would like to wait out and wait to hear back and get some more clarity on these provisions before taking a step forward in this regard.
Vibhav, your thoughts on this?
Sure. I think Dr. Saraf has captured it quite succinctly and has articulated the approach. I think the government has rightly so kept a residuary power to tackle certain of these. I don't think so. They intend to stop or restrict cross-border transfer across it. We may be allowed to. There may be critical, sensitive areas, sectors, or data sets that they would want to mirror or restrict transfer outside the country. And that's what they have kept this as a residuary power. But because it's ambiguous, there are two things I just wanted to highlight. I think because we have dealt with cross-border restrictions, there was a lot of advocacy. The government really accepted the need for cross-border transfer, ease of cross-border transfer, rather than a very restrictive approach that Europe has taken for India's next stage of tech. So one of the things that I think is missing out in this provision is targeting only SDFs. I think if cross-border transfer has to be restricted for a sector, it needs to be irrespective of the kind of data fiduciary it is. That's one thing has to be considered, because tomorrow when a rule has to be made and it's the finance sector, then the entire sector or the payments, for example, would have to be regulated in that manner. So therefore, I think this cross-border transfer should not have come, a restriction should not have come under the significant data fiduciaries additional obligations, but should have been catered under the section and the rule making under the section of cross-border transfer. Right. That's the first point. The second point, I think, is we'll also have to be conscious that whatever we transfer, that there needs to be a possibility of India being considered adequate in terms of data privacy protection, right? So the government will keep those things in mind. And hence, I don't think so we need to worry too much and panic. What we need to do is maybe be proactive in consultations to help the government understand the different case scenarios which would come about, which this rule might make it restrictive or may not cater to, something that we touched upon, that SDF versus DF in the same sector, right? So that's how I would approach it. I am not worried that they'll stop they'll stop a transfer of employee data which is stored in a global database for an MNC or a customer data. Maybe critical sensitive data which is integral to national security, sovereignty is something that they would talk about. One of the good things that I at least believe is, which Dr. Saraf touched upon, is the committee. I think it requires certain harmonization, consistency across cross-border restrictions, retention, etc. While this is only for cross-border restriction, I think that committee talking to different sectors can lead to certain harmonization, which would be beneficial for the industry. But as I said, I think this needs to be devoid and agnostic of SDFs and for the larger data fiduciary set.
Before I come to Mr. Maheshwari, who does not represent the government for sure, but has had a long tenure there, can I quickly take your views on this, Hena, on cross-border data transfer? Do you see any potential risks coming in, especially again in your case, since you're a part of a larger global organization in terms of data transfer? Do you agree with Bibhav and Dr. Saraf that it's likely that the government will take a rational view on this overall data transfer piece?
Yeah. So while agreeing with both of my fellow panelists, I would also still like to remind that the law continues to be what it is, and the rules do not cover the whole of Section 16 in this case, which means that the sectoral regulators they have defined any restrictions on the data movement will continue to be in existence in addition to what the rules are or what the rules have been proposed as such. So maybe I agree that why create two buckets of SDF and non-SDF is data is critical, but probably through a combination of what the SDFs are plus what the sector is, maybe you are able to take care. And through the rule 14, which restricts certain data being shared with the foreign states or the instrumentalities of the state, this is, as Bharatji pointed out, this is more of a geopolitical and maybe the bargaining power that government is trying to have, which unfortunately was missing in the act. And this is where I'm sure, I mean, during the inter-government consultation, which also appeared to have been ongoing, which resulted into delay of publication of these draft rules, probably had some role that we should not really lose sight of that, I'll say, power being exercised and being available to the government. The only sad part is that it is being proposed through the rules. It could have been, I mean, in the act itself. That's it.
Hina, your views before we probably take one more question, Kanishka, which you can go through and let us know which one. But in the meantime, Hina, if you can give your views on this as well.
I'm actually waiting for the order, the general order or the special order. I think that will give us some light. Otherwise, the 14 and the rule 14 is quite generic, and I cannot infer much from it. However, coming to manufacturing, mostly like for US and UK, I don't think, or the European Union, where generally we have business. I don't think there will be any restriction because per se they also like the GDPR and the other parameters when it's applicable, when we are capturing their employee, our customer or the vendor employee data, we follow that. However, but not much, because we have a B2B segment. Again, from the healthcare perspective, the medical value travel facilitator, that is the registration and the license that healthcare companies take, and they process the PII, the healthcare data. So I'm waiting for actually the MVTF license is mostly for the countries where they do not have a proper healthcare facility. From African countries or Middle East countries, most of them come to our country for though I'm sure the DPDP is not related, but I'm just trying to say that we have to wait for those special or general orders and see what are the restrictions. Otherwise, we are still I want to know and move from there.
Sure. Kanishka, so we probably have time for just one more question. So over to you.
Sure. So this is more an implementation question, and I think a lot of our clients have asked that they have already implemented GDPR for some of their subsidiaries, and brought in more of a global policy. And something that we've also noticed, because recently we've come up with an offering of assessing preparedness of data privacy. So we were reviewing policies, and a lot of it has been taken from GDPR. So I'll ask and start with Dr. Saraf. So what do you think about these organizations? Like, how much do they have to now change, or is it more in alignment with GDPR, and they can continue what they're doing with respect to their policies and procedures?
You're on mute, Dr. Saraf.
I'm sorry. Most of the organizations who have so far been compliant with GDPR or global laws are under the pretext that, hey, we are already compliant and we need to do a few tweaks here and there. But I think there are a few lessons to be learned from the GDPR. And before I get to two important lessons, I think one important aspect on the business impact side and the change that will happen in the Indian ecosystem is going to be basis the notice and the consent requirements. So because if you look at the GDPR, consent is the last lawful basis of processing. They never relied on consent to be sought from users. In fact, they asked the data controllers, as they call it in GDPR, to start processing the data after conducting a legitimate impact assessment test. So there was no interaction between a data controller and the consumer, say, for example, in a B2C space. Taking that into an Indian ecosystem and under the Indian law, we have to seek consent from the consumers. There's going to be an interaction, and India is diverse. So imagine the amount. So if you have, say, 100 million customers on your platform, imagine you need to seek consent, one, to allow them to actually understand what consent is, creating that particular awareness in the entire ecosystem, plus allowing them to consent, and then we start processing that data. Right. So that is going to be a big challenge for the Indian companies, because our lawful processing is going to be basis consent. Now, how are you going to operationalize this? What are the effective mechanisms to get that consent sought from the consumers? And I'm talking more from a B2C context standpoint here. I think this is going to be a big challenge, and there is an expected business disruption as soon as there is a rollout of this act. So be prepared for that is what I would clearly call out. The two lessons that I have learned and would like to pass on to the people listening today is basis the GDPR enforcements. One, clearly, do not believe that you can roll out a privacy notice and a consent and sit over it for years together. You need to keep it updated. You need to have your backend systems integrated. You need to have your records updated, because we have seen GDPR enforcements and the regulator going after the data controllers because their notices and consents had already expired, and there was new processing that was happening and the consumers were never reached out to. That's one. Second, this is a preparation for a long haul. Think about privacy and build it as a DNA in your organization, because if you don't do that, data subject rights, which is going to be a huge impact for B2C businesses, is going to come and bite you, because there are going to be a lot of compliance requirements that the data fiduciaries will have to comply with, including responding to data subject rights within a certain specific timeline. And if you don't do that, they have the right to go to the board and complain, and then there is going to be an investigation on you, right? So I think people and mostly data controllers and data fiduciaries in GDPR and our context, we have seen that there is a lax approach on this particular aspect, which has actually triggered investigations and an enforcement action from the regulators under the GDPR. So I think these are two critical lessons that I would like the audience to know as they go about the implementation journey, and if they believe that if they are GDPR compliant, they are compliant with the Indian law.
So we are absolutely out of time, because we'll have to take some of the live questions which are coming in. But quickly, if we can run to Bivav and then the Hina and Mr. Maheshwari on this before we end the session with this part of the panel discussion and move to the next phase.
So I think Dr. Saraf put it rightly. So I think the most important is the lawful basis assessment. I think it's important, and there has been a lot of debate and questions around 7A to be used as legitimate. It is not. 7A is highly restrictive. It's coming out of what Singapore had under deemed consent. And if you see how decisions have come about around that, it needs to be highly specific in time and reasonably and very objective. So hence you can't expand 7A to the extent how legitimate interest is used. So therefore, consent does become a primary basis, and that would create a lot of disruption. So therefore, I think businesses will have to prepare for that. The other aspect I just wanted to quickly touch upon is that unlike the GDPR, which does impose certain obligations on processors, while the data controllers are, or the data fiduciaries are primarily accountable, the data processors also have liabilities. We've seen the ICO UK imposing penalties on the processors. Out here in the Indian law, they're completely shielded under the guise of data fiduciaries, and hence I think a third-party risk management program may have to be a little more robust, because GDPR organizations are looking at it at it as contractual passing of risks, etc. And hence, I think that is something we should focus on. It's a humongous task for large organizations, but that's one area that I think people can look at. The last, I would want to reiterate that DSAR becomes very important. I think what the law wants to do, rightly so, for us also as consumers, if we put ourselves in the shoes of a consumer, is that give control over our data. And organization need to prepare DSARs in a manner which is integrated to their backend data to make it efficient. You can do it manually for a small organization, have a website with a form, etc. But for large organizations with disparate platforms, etc., integrating these become highly important. Otherwise, as Dr. Saraf mentioned, you look at the Carrefour example in Europe, a non-fulfillment of DSARs have led to a proper investigation into other privacy practices, not only grievance redressal. So therefore, these are the 2-3 points cautious of the time. So that's it from me. Thank you.
Hina, any specific thoughts on this?
I think most of it are covered by Bharat and Vibhav, and I think Maheshwari sir will also want to add a couple of points. One, the important point for us is the consent manager portion and the obligation on the first schedule is something which actually has given a brighter side on the handling or the processing of the data. So a lot of weightage has been given to consent manager, and consent manager can be a body corporate or the data fiduciary who also can establish a separate team of people who will act as independent consent managers. So I think consent manager is something which we will want to explore more. Yeah.
Sure. Mr. Maheshwari, we will end this part of this discussion with you.
Yeah. And once again, I'll come a bit differently. Those organizations who have implemented GDPR understand at least GDPR. They understand the nuances of what is different between GDPR and DPDP Act. So for them, the journey is differentiation. The journey is change of context, that now you are talking about the Indian users and others. But then there are huge number of, I'll say, stakeholders, MSMEs, who are just catering to the Indian market. Then there is government, which is also required to implement the DPDP Act. For them, I mean, moving from the current regime to what the DPDP Act requires will be a huge change. Yeah, that's it.
Sure. No, I think this is an excellent summary of the rules and what people should be prepared for. We have a very few minutes left, but we'll quickly move to the live Q&A. Thank you again for all of you who have been able to join this session. We'll move to the live Q&A now. Thank you very much.
Yeah.
Thank you.
Thank you.
Thank you.
There have been a lot of questions which have been asked, and we've tried to respond to some of them. One question which I think if Mr. Maheshwari has joined, that has come across from a whole lot of different people is the applicability of the act and the rules to different classes of people, from different types of companies to consultancy firms. And while the generic answer is that it applies universally to anybody doing business in India, Mr. Maheshwari, would you want to spend a minute just to give that clarification? Because there seems to be a fair amount of ambiguity about this in people's mind, because there were a host of questions around whether the act and the rules will apply to one set of businesses or another set of businesses. So I wanted to quickly check with you, Mr. Maheshwari, if you're on in the session, if you could turn on your video and if you could please answer the question.
Yeah, should I respond?
Yes, please.
In fact, as conveyed by you, as long as you are in business and not collecting, processing data for personal use, domestic use, the act actually applies. However, only with respect to that personal information which has been posted by you in a public platform. Once again, the scope of the act is outside. I mean, so that particular information will also be outside the scope of the act. Barring that, my opinion is act applies universally to everyone, as long as they are providing services and goods here in India. And when it comes to foreign entities, it is automatically understood that somebody, seeing somebody else's website is not a business. So therefore, if you have a systemic business being done in India, your websites are directed towards maybe India as one of the business constituency, then the act applies.
Yes, I think that should provide a lot of clarity to a whole host of questions that were asked. The next question I will first direct it to you, Dr. Saraf, again, being asked by a lot of people with regard to employee data. And I think various, members of the panel, participants who are especially in human resources have this very serious doubt about how long do they need to store employee data? Do the employee contracts need to be modified? What is there legitimate use around employee data which can be considered? So if you can provide us with some clarity with regard to this entire, space around employee data, I think that would be very helpful.
Sure. Luckily, employee data, there are different grounds for processing employee data. It need not specifically be consent, which is a great push under the Act. So what that entails is if right from recruiting a candidate to converting him to an employee on your payroll, all of that can be driven through the employment contract that you may sign either with your recruiting firm to start off as a candidate, or when you convert him into a full-time employee on your payroll through the employment contract. Having said that, I think again, we need to be cognizant of the fact that this act is a principle-based act. So there are certain principles that you will need to adhere to. For example, data minimization, data proportionality, ensuring that whatever is being collected is being protected. So what does that principle-based or what implications do these principles have is very critical to understand. Say, for example, if you're collecting employee data, you should collect it only for the purposes for providing him, providing you employment in that particular sphere. So you cannot go above and beyond of what is expected for him to provide and provide the employment service to you as an employee. So you have to apply the principle of data minimization. You have to apply the principle of data proportionality. Now, how long can you retain both candidate data as well as employee data? This is also not specifically called out under the Act, but you can have your internal SOPs defining the purpose for which you need to hold data. What the regulator will be interested to look at, whether the SOP that you are defining, the purposes that you have listed down for which you have captured certain specific data elements from the employee, are they in line? Are you going beyond the principles of proportionality, or have you collected excessive data for which the purpose is already over, right? There are these very standard questions that there are candidates who have applied, but they did not get converted into an employee, but we want to hold that entire database with us so that when there is a vacancy, we can contact them. So that is still possible, and you can hold on to that data, but it should be a reasonable effort from your side to ensure that if there is, those particular roles do not exist anymore, or for example, it's been a certain period of time, say, from the intent of the legislation, it looks like 3 years is a reasonable period of time. So for over a period of 3 years, you are not contacting that particular employee, or neither the employee has interacted back with you. So these are the sort of retention timelines that you need to define internally as part of your SOPs and procedures to retain and further delete that data. So again, there is a lot of leeway given by the Act and the rules, because these are again principle based, as I started answering this question, and I've mentioned throughout the discussion as well. So define and understand what are your purposes, what is the purpose limitation, and how long you need to retain data. And over a period of time, I think it will mature and you will be able to further assess the reasonability test to understand when you should retain and when you should go ahead and delete that data. So that is my view on employee data. Anything specific that anybody would like to know about employee data? More than happy to help on that particular piece as well.
Sure, we will direct them towards you. The next question I have is to you, Bibhav, and that's again, I'm kind of consolidating a whole lot of different questions that have come in with regard to if we have already taken consent from people, will that be sufficient? Will I have to take fresh consent from existing users, existing clients? And also another, context with this is with regard to contracts. If we already have some contracts, be it with vendors, be it with employees, be it with customers, how do we need to modify them to, or do we need to modify them? I think is the more basic question for them to be complying with the requirements of the DPDP Act and rules. So, Bibhav, I'll start with you and maybe come to the others as well.
Sure. And so I'll start with the aspect on consent or taking consent for retrospective data. If you read the rules along with the Act, what it can be interpreted is that consent is not what is being sought. It is notice that you need to provide to the consumers, your customers and partners whose data you're processing. Now, what it entails, and it is a way of consent that would come about in a different way, because if you see the notice, and Dr. Saraf spoke about the itemized items or itemized details in the notice. One of the aspects is a communication link to the app or website to allow opt-outs, etc., or withdrawal of consent there. So what I would expect, or what companies should be doing, is notifying them through whether it's, if they have mobile numbers, then through SMS, if it's e-commerce website, through the application itself, if it's email IDs, then through email IDs, the privacy notice. However, the privacy notice should have that possible way of opting out or withdrawal of consent, and that is how I would assume companies would be complying with this aspect of the law. We do not need to do an explicit consent, is what I believe, unless there are guidances to the contrary by the board after it gets established. But I would not think so, because it cannot be interpreted in that manner. That's how I'm reading the Act and the rules. Coming to contracts, now we did touch upon that. I think we will have to look at contracts. I would advise, and once the rules are finalized, the reasonable security standards that will get finalized in whatever form they do after consultation across different stakeholders in the ecosystem, that should ideally be reproduced in the contracts. It's something very similar to what the GDPR has. It puts a statutory obligation through the legislation. This is something that has been provided by the rules. I think what we can do is pass it contractually, because the law does not impose obligations or possibility of fine. It may change as we learn and get into this journey. But what ideally I would recommend is change contracts to the extent of passing the liability of these compliances also to your partners. Standardize it so that everyone has these minimum standard requirements. Your processors are obligated to think from their context, what is the minimum standard that they need to implement when they're providing service to you? Because one thing that is there, and then how you go with a high risk, low risk approach, where there are some vendors that you may have to engage at a greater length, have more control. But the lower ones, you may have canteen services where certain limited details are being given, where even the risk is very low. So the battle has to be fought in phases, as Dr. Saraf said, right? So, and hence what you choose is more sensitive processing, sensitive data, and then progress. So the standardization of contract would lead to passing of liability. Time will tell how this will be litigated and how successful it would be, or it'll be a burden. But I think if it becomes a burden and compliance and enforcement becomes a problem, I'm sure the government with their approach will amend the Act rules to bring in learnings from our experiences.
Okay, I'll just ask one further question to Dr. Saraf, and hopefully we'll be able to pass it through the room. And that's again a question that has been coming in different shapes and forms in terms of, people are at different stages of being fully aware of the act and rules and what they need to do thereunder. Uh, what kind of preparation do you recommend people start if somebody has not done anything yet? Let's say that's the stage that they're in today. And the draft rules are here. The act has been there for well over a year and a half now. Dr. Saraf, starting with you, just a quick response because I think we are
Yeah.
just 2 minutes away from end of time on what could they do between now and let's say the next 2 months.
So I think if you have not started on the privacy compliance journey yet, you certainly first need to start to set up a core privacy team. That can be currently with your current resources. You may work around within different teams trying to find out the particular expertise. So setting up that privacy organization at this stage is very important. Second, I think most importantly, I think you need to have a tone from the top. You need to build a culture, as I said, right? This is a long haul. Do not consider this as a short-term fix. So you all need to get the tone from the top, from the leadership. So take a buy-in from them and start building awareness, creating that culture across the organization, across different functions, right from your HR, your finance, your legal, to your procurement. All of them have to be a part of this entire piece. The third one is, of course, get your budgeting right. Think about your roadmap as to how we are going to go about the implementation. Start to note, maybe look at the best practices around, get some consultants over just to understand what the ecosystem is doing, how are they preparing, what are the best practices that are flowing. Create your own roadmap for sure, budget it right. And then I think from an implementation standpoint, the first thing you need to do is start the data discovery exercise. Because first you need to identify what data lies within your organization, what historical data you need to roll over. As Bibhav rightly mentioned, you need to provide a notice of all the particular personal data elements about a user or a consumer that you hold, or and how you want to roll that over by giving that particular notice. So data discovery would be your first step if you have not started on the implementation side. And then basis the understanding of your ecosystem, I think you need to start pushing ahead with creating a program of privacy, including different policies, procedures, guidelines around how you're going to run that program, and then eventually turn that into actionables with the use of notice and consent to the users, and carry on further with the other compliance requirements. So I think the basics are these to get the ball rolling is what I would say.
Yes, Biba.
So just one aspect, I think Dr. Saraf, as I put it across very well. I don't think so I have anything else to add. I think that's a good starting step. Just one thing, a bit of out of experience, and I think it'll resonate with anyone who's tried working around privacy for the last couple of years. I think this will test lawyers, privacy expert within the organization, whether they are true business partners to the organization. I'll tell you why. And then there are questions around whether there are tools to help you do all of this. I can guarantee you there are tools which will enable it in subsequent stages towards compliance, but data discovery is going to be a task which is possible if you have someone who understands the business, the operation, and the interface of data within that environment better. You can get a Deloitte, a PwC, and they will be lost within your organization trying to find out data discovery and data mapping. That's been my experience. I don't know about others, but I think there needs to be a person within the organization that shows how true or you're to your business and how well you understand your business. Because what will allow you to do is, because personal data is there everywhere across the business, it may be for, if I'm signing a contract with Lexplosion, you have my personal data as a SPOC of HUL, right? It may be my phone number also, but do I treat it as a highly sensitive data processing activity to start looking at contracts with Lexplosion, or do I focus on my employee data and my data where I'm taking health data, etc.? So therefore, understanding the business operations and mapping that internally with someone, and I understand there may be resource crunch, not everyone may have a large team to do that, but taking help from outside, but owning that piece within the organization is very important. That would be the most important step. after you realize it, and you may be 70, 80% right, it's a long journey, it at least gives you comfort that, okay, I know at least 80% of my processing activities. The smaller ones are low risk ones. Let's start with the compliance. If there are any issues that happen, even a regulator, I'm hoping, with the kind of conversation the government is assuring us with about a practical approach, they'll also see that if the organization had taken those steps to identify those high risk ones, the subsequent ones, the smaller issues, would be looked at with certain with lesser fines or improvement notice, which is a possibility within the act. So that's one big advice I would give to any organization, MSMEs, SMEs, or large organizations.
Absolutely. I think you've hit the nail on the head. Knowing your own organization, partnering with businesses is very, very important. On a slightly lighter note, first of all, I'd like to thank both of you and Mr. Maheshwari and Hena, Mr. Maheshwari just dropped off and Hena couldn't join us for this last session. And of course, to every person who's joined this session, really appreciate it. And on a slightly lighter note, Deloitte and PwC are not your solutions. You need to come to Lexplosion, and you will be able to get your, data assessment done with a far more pragmatic, practical, and of course, cost-effective manner. So, if you're looking for a partner to assist you with this journey, you know who to reach out to. Thank you very much. Have a wonderful, wonderful evening. Here's to a fantastic privacy journey for all of you, and to further webinars on this subject in the days to come. Thank you so much, everyone, for joining the session. We're ending the session now. Thank you very much.